Hello dear students, it's Umida Khaydarova today with you, and we're going to talk about litigation, term which is very famous and frequently met in the legal field. You know what is dispute? Dispute is usually occurs between two parties. If a dispute is not settled by agreement between the disputing parties, it will eventually be heard or decided by a judge in a court. And a lawsuit before court is referred usually to as the litigation. In the litigation, there are four phases, which include pre-trial phase, discovery phase, trial phase, and enforcement phase. In pre-trial phase, when a dispute arises, one party will usually have their lawyer send a letter to other party in an attempt to reach a settlement. But if the settlement is not reached, then a formal action starts usually, and the lawsuit is filed usually. It happens in pre-trial phase. In a discovery phase, usually one or both parties gathers evidence about the disputing by taking the testimony of witnesses, examining documents or physical evidence, or requesting evidence from the other side. That's why the phase is called discovery. You discover what really exists and what is related to the process, legal proceeding. In the trial phase, usually all the facts related to the case are heard in a court. Or usually in this process, a jury can participate as well in the court. And the court delivers a decision, a judgment in the case. It happens in trial phase. In enforcement phase, usually we know that the case in the court is usually won by one party and is lost by another party. And in this phase, the losing party, it means the party which has lost the case, may file post-trial motions to convince the judge to amend the judgment, or may decide to appeal to a higher court. Right? And but here, usually the losing party may appeal to the court, and maybe later, in a higher court, this losing party may be winning party as well. And this all happens in the four phases of litigation. But litigation is the most formal option and potentially the most expensive and time-consuming. And however, litigation will often have negative impact on relationship between parties, and can be bad for businesses, because usually after solving the dispute, the businesses usually keep going with their businesses. And this relationship may be faulty and not pleasant to both parties. And in this case, usually not litigation, but the mitigating procedures may help. And in these procedures, you may face even the much more less stressful and time-consuming procedures. And we will talk about it later on the next our video lesson. We will talk with you about different methods of ADR. But what is ADR? In our last session, we talked with you about the litigation, the term which is usually used to distinguish lawsuits from ADR methods. ADR is alternative dispute resolution. The methods of the ADR are negotiation, arbitration, and mediation. So I think that you know these words because you usually meet them in different books, in your lessons. But what are they? These three terms. And we will talk about advantages and disadvantages of ADR. So, what is the advantages of alternative dispute resolutions? One of the primary benefits of ADR, the various types of ADR, is its cost effectiveness, because usually not all people can afford much expenses spent usually on these legal proceedings. And the second advantage is speed. Similar to expensive, alternative dispute resolution processes do not typically last nearly as long as the litigation. And ADR is often much quicker than litigation. In the USA, the average contract-based lawsuits takes 2 years. And similar cases in arbitration can be as short as 5 or 6 months. You see the difference? So, and the next advantage of ADR is less stress. Most people have very little experience in filing a lawsuit, going to court, or participating in the legal proceedings in the court. Even some people who may first face such kind of proceedings may be a little bit embarrassed in the next coming court. And the alternative dispute resolution methods, the process can be less stressful, and it doesn't usually involve the formal court appearances. The next advantage is confidentiality. You know, people have secrets, or even if it's not a secret, they have some issues they don't want to be spread to all people around themselves. And usually ADR is conducted privately and confidentially. So when disputing parties meet, the terms and solutions they discuss are not necessarily open to the public. And here's the factors of trust work. While the ADR has the advantages, it has the disadvantages as well. And what are they? No guaranteed outcome. ADR doesn't always come with a guaranteed outcome or solution to any legal dispute. Next is lack of consistency. ADR is designed to be flexible and with few restrictions and limitations rather than litigation. But however, with all this flexibility comes the possibility of inconsistency. Why? Because you may hire one mediator to resolve the dispute, and within the next mediator you hire, he may work entirely differently. So you see, it's not like a constant procedure to use ADR methods. And even those people who have used ADR before are not so sure about the outcome of the legal proceeding. And next is limited scope. What is limited scope? And in this methods is not the method. The ADR is not designed as a substitute for litigation, and there are some limitations of what can ADR do. For instance, it usually occurs in the process of divorcing, because in the proceedings of divorcing, usually parties want to have it not on their own, but they want the court decide to what party usually child or children go. And in involving child custody or legally incapacitated people, this scope usually can cause different confusion and misunderstandings as well. So I think the advantage and disadvantage always exist in all fields. And I want to ask you, have you ever experienced using any ADR methods or not? As a home task, I would like to ask you to write your own experience. Maybe you used these methods, or your relative or your friends. Write such kind of written assignment using 120 words to cover the question: how I experienced the ADR methods, how effective they were, and what was the result, and do you recommend such methods to your friends or not? So I hope that my session was new for you, and if you have any questions, you can contact me, and I will send my email and contact numbers to the channel that you are going to upload the video. Thank you so much. Goodbye.